Good morning, everybody, and happy election day. I hope this is a welcome break and distraction from everything going on the news right now. And today we're going to be talking about legal tips and options that relate to starting your small business. And if you're already in business, a lot of this is still going to be, I think, very helpful, but this is going to be particularly helpful for those who are interested in starting a new limited liability entity. And if you're not familiar with what that is, we'll definitely get into that in more depth. And before we get started, I just want to point out that everything in the presentation is meant to convey very general information that is not specific to your specific individual case. So it's not to provide legal advice or opinions. So if something is going on in your business or you are starting a small business, please consult with or retain a qualified attorney or potentially a financial advisor or accountant on all matters contained in this presentation. I briefly want to talk about what my program at Legal Aid Service of Collier County offers. I work with the Florida Community Development Legal Project, and this is a statewide collaboration between several nonprofit agencies. And what the FCDL statewide program provides is absolutely free legal representation to small business owners, and if that business is owned by low to moderate income individuals, which is up to 140% of your area median income. In Collier County, for a family of one, that's about $70,000. For a family of four, it's over $90,000. And in addition to serving small businesses for free, we also represent nonprofits that serve the low to moderate income community. And some examples of the free legal services we provide are right from incorporation to internal operating agreements, such as bylaws, operating agreements, or partnership agreements. We can draft or review contracts for you, leases. We are involved heavily in negotiation right now. That could be negotiation with your commercial landlord or negotiation with clients or vendors. We create client template agreements so that you can always fill in the information and customize and use for each of your clients. We do Florida trademark registration and much more than that. Essentially, what we want to try to do is be free in-house corporate counsel for our small business clients. And if you believe that you qualify for our services or are interested to see if you are, at the bottom of this slide is an email that you can email and provide your business name information on what legal services you believe you need. And Sherry, our intake specialist, will walk you through our intake steps. So her email is at the bottom of the screen, and you can email her if you are in Broward or Collier County. However, if there's anyone outside of Broward or Collier County, this is a statewide program. So if you are outside those two counties, there are still legal services available, but rather than emailing Sherry, you can go to the website link at the bottom of the screen to apply for services and read more information about the Florida Community Development Legal Project. And today we're going to be talking about 4 types of entity structures to choose from, and that's sole proprietorships, partnerships, limited liability corporations, abbreviated as LLCs, corporations, and then in each of those 4, we're going to look at the different liability that each has and how it can protect you personally from the liabilities and debts that your business has. I will talk about the importance of internal operating documents for each. For a limited liability company, that internal operating agreement is called an operating agreement. And for a corporation, it's called its bylaws. And a partnership, it's partnership agreement. So generally the same thing, regulates internally how the business is going to be run. It's an internal document, it's not public knowledge. However, they really all effectively function the same with those 3 different names. We'll also talk about how you can lose liability protections, a phrase that's often referred to as piercing the corporate veil. We will very briefly touch on taxation, And finally, finish looking at fictitious names or DBAs, doing business as. So as mentioned, the corporate structures to pick from when you begin are sole proprietorship, partnership, LLC, or corporation. And generally the best thing you want to do is develop a business plan detailing the business's objectives and ways to achieve them. And that'll help you determine which is the best entity to use. And if you haven't been working with some of Collier County's absolutely amazing free resources for small businesses that give small business technical guidance, they can help with business plans, review financials if you're applying for the SBA disaster loan or other types of loans or grants, Collier grant money. If you're on Broward, the Broward CARES grant funding that will open its application on November 9th. Also worth mentioning today that if you're in Broward applying for that they have opened today a portal that the county will work with you and provide free technical advice so you can be as ready as you can for applying on November 9th. So if you need that information, please feel free to give me an email. My email will be at the end of the slides. And those organizations that provide this kind of one-on-one counseling and classes, the first one is SCORE of Naples. And SCORE of Naples can team you up with a business mentor. They can help you draft your business plan. They can help you with pricing, market evaluation, social media, and they are just an absolutely fantastic organization. In addition, in Collier County, we also have not just Collier County, this is also Lee County, it's all Southwest Florida, and it's called the Goodwill Micro Enterprise Program. And they do several courses a year, intense courses. I think they meet 2 times for 3 hours a week for several weeks, and they will focus on several topics for your small business, and it's sort of a crash course training. And some graduates of their program are able to apply for micro enterprise loans or grants from Goodwill, and both are slightly different but offer amazing benefits to small businesses. And I highly recommend, if you're in Collier County, Broward County, or Southwest Florida, to take advantage of those. Over in Broward County, they also have the Urban League of Broward County and SCORE in Broward, also fantastic resources. And in some, they can help you create your business plan. And once you have that, it'll be much easier to determine which of these 4 business structures is best for you. A sole proprietor is the first we'll look at. And a sole proprietor doesn't require any kind of incorporation, meaning they don't actually have to file anything or do any registration with their state. And a sole proprietorship is owned by a single individual. So there is no distinction between the individual owner and the business. And we'll talk about why that's really problematic in the next couple of slides. And if you're operating as a sole proprietorship, pretty much if it's just you individually and you haven't actually registered an entity, you don't have any partners you're running the business with, your default is going to fall that you are a sole proprietor. And as a sole proprietor, you have to operate your business under your individual name. So my name is Callie Soldavini, and if I were going to start an auto parts store, I would have to run the business as my individual name, Callie Soldavini. However, if you want to, as a sole proprietorship, to operate under a different name, you can do that, but you have to register it, and that's called a fictitious name, or DBA, doing business as. And you can do that by going to sunbiz.org and clicking the forms for a fictitious name registration. There is a $50 filing fee. In addition, the second requirement is that you have to publish a notice of the fictitious name in the county's newspaper that the business is headquartered. And there are lots of services that do this online. If you just want to Google fictitious name, publish notice, several companies should come up, and each of them run about $100. But those companies will know exactly what the language is that you need to put in that notice. And it's, in my opinion, a silly, outdated rule. Nonetheless, it's still Florida statute that in order to operate a sole proprietorship under any name that's not your individual name, you have to register this fictitious name, and you also have to publish it in your local newspaper. Similarly to a sole proprietorship, a partnership is a legal relationship when two or more individuals carry on business as co-owners and share in the profits. So just like a sole proprietorship, if you and one other person or more are operating a business and sharing in the profits, then you will automatically default to a partnership. And in a partnership, you should absolutely have a partnership agreement that will spell out the details of the partnership. Because if one is not created, Florida statute will impose terms on you and your partners that you may not have intended. For example, if there's no partnership agreement, each partner under Florida statute, it will default to. Each partner is a 50-50 owner sharing equally in the debts and assets of the company, of the partnership. But maybe you put in more work or more money and you believe you're entitled to 70% of the assets from the company. Unless you write that down in a partnership agreement, it doesn't matter. Oftentimes it doesn't matter what you thought in your head, or even generally a handshake that you and your partner agreed to, because it's going to be very difficult to enforce that in court. So again, my recommendation is, strong recommendation is that you're operating any business, not just a partnership, but any business, you should have this internal operating document. And for partnership, that's called a partnership agreement. And as I mentioned, that's called something different for an LLC and corporation. And we'll definitely talk more about those. But for now, I want to separate sole proprietorships and partnerships, which are kind of in their own bubble, different from the other two structures, limited liability companies and corporations. Actually, let me backtrack one moment to partnership agreements. Some bullet points you can include in them. You will want to include the duties and responsibilities of each partner and what each partner's responsibilities are as it relates to the management of the business on a day-to-day basis. How and when capital contributions are made, how much each partner put into the business, and how much each partner is going to own and get paid from the business. Especially if you have an even number of partners, 2, 4, 6, explain how voting ties are going to be decided. Will there be one partner that gets to break a tie if there is one, and how income taxes will be spent. So as a reminder, if you don't have a partnership agreement, then state law is going to determine the partnership terms, and it may not be something that you and your partners wanted. And if you want to see what those terms are that would be imposed, you can Google Florida Statute 620 and see exactly what Florida statute imposes on partners that do not create partnership agreements. But you want to take the opportunity to have the freedom of contract and draft your own terms. And then again, going back to separating sole proprietorships and partnerships from LLCs and corporations, the big difference here is a limitation of liability. And that's something I'm going to say throughout the presentation and until you walk out of here, that you might even rather watch the elections than hear me say limited liability one more time. If your business incurs debt as a sole proprietor or partnership that it cannot pay back from its profits, then you individually are personally liable and responsible for that payment. And that means that creditors can sue you personally to satisfy the debt and collection of your individual assets. But that's not how it has to be. Because with the other entity structures we're going to focus on, corporations and LLCs, there are more formalities that you have to do to keep up with the business, and we'll go through those in detail. So while you have to put in a little bit more work to have formalities, you are not personally liable. Your business is, because we've separated you individually from your business. So the law sees them as two separate, almost people. In the eyes of the law, your business is a completely separate person from you individually as a person. And then of course, there's always exceptions that you could sign away, such as a personal guarantee. If you have a limited liability company, such as an LLC or corporation, and you sign a personal guarantee for your commercial lease, this still opens you up to personal liability. But absent some kind of document or agreement otherwise, having an LLC or corporation protects you individually because the assets such as your home and your car and your electronics and your investments and your savings, those are protected from creditors or any individuals or companies that may want to sue your business, because they're suing your business, not you individually. So the benefits of limited liability companies and corporations are immense compared to sole proprietorships and partnerships generally. The limited liability for LLCs and corporations involves different requirements that sole proprietorships and partnerships do not have. First, you must register and pay a fee with the state on sunbiz.org. Second, you have to file and keep up with an annual report that requires paying an annual fee each year. And third, you may or may not, as we'll talk about when we talk about taxes briefly, file a separate return from your business. A sole proprietorship and their business are all filed on one tax return. So when you come to an LLC or corporation, you may file a separate tax return. And so these are just more formalities, more of a headache for business owners to have to keep up with. They're having to pay these fees. One fee they have to pay every year. Their taxes may get more complicated. But in exchange for those headaches, you get more liability protections because your business is a separate legal entity from the owners or the shareholders. For limited liability companies, more specifically, the requirement is to register at the Florida Division of Corporations an organizing document called your Articles of Organization. And in addition, that is a $125 filing fee. So again, this is not something a sole proprietor has to worry about, but a sole proprietor does not get the benefits of limited liability incorporation. LLCs can be single member or multi-member. So if you're a sole proprietorship and you're not worried about any other partners, you can still incorporate as an LLC and receive those limited liability protections. Or if you have multiple members or owners, then you can all come together to create the LLC. And finally, some lingo, legal jargon. Members are what Florida statute calls the owners of an LLC. So members are the owners, while the managers run the day-to-day of the business. And you can be one or both. So if you're not only an owner in the business, but you also run the day-to-day of the business, you're what's considered a managing member. But you can also have officer roles in your LLC if you'd like, such as president, vice president, secretary, treasurer, or you can just rely on managing member. But if you operate as maybe a passive investor, you've given funds to an LLC and you're not interested in running the day-to-day of the business, you just want to give your funds sort of as an investment into the LLC and let someone else run it, then you would only be considered a member, not a managing member. So just if we refer to those terms throughout the presentation, that's what they mean. And essentially, it means owners, members, and managers running the business. And the limited liability for corporations that you receive, like an LLC, corporations also have similar limited liability protection. However, corporations have a few bit more formalities than LLCs. And a couple examples of the more formality is that corporations should meet at least annually. Records of corporate minutes or major decisions need to be kept in a corporations. Corporations have to have a board of directors. And these are things that LLCs don't generally have to have. So it's just a couple bit more formalities. But just like an LLC, the corporation must register with the state, called the Articles of Incorporation, and pay a $70 filing fee. And again, to drive that point home, the LLC and corporation's benefits are immense. The benefit is that you are not only liable for debts and assets held by the entity. Your personal debts and assets held by you are separate because, again, it's two separate legal persons, your business and you yourself individually. And if you're operating as a sole proprietorship or general partner, you're not going to get those protections. So in most cases, again, this is general information and an attorney would have to look at your business plan, but in most situations, a corporation or LLC is best. For most of my small business clients, LLCs are better because they do provide a little bit more flexibility than corporations. And whether you're an LLC or corporation, just like when we talked about the partnership agreement, you will want to have an internal operating document for your corporation or LLC that details operational and financial management of the company. So that may include how the business will pay taxes, distribute profits and losses between members, its owners, different voting rights, how voting ties are broken, how it's going to be managed, who is the manager, who is the member, because if you don't list that out in the operating agreement for an LLC, again, Florida statute might impose something on you that you didn't intend to. Or you'll have to dig through records and emails and try to prove to a court at times that you are actually the owner if there's any kind of lawsuit or questioning if you are actually the owner. So don't make your life difficult. Just put in your internal operating agreement, aka your bylaws or operating agreement, exactly how you mean the business to be managed. Because if something happens to you or you get in a dispute with others in your business, it is just a huge mess to have to prove all of that to a court, and instead just put it in the document. For example, I had a client a few months ago that did not have, they had two business partners that were dating and they had a falling out, and one of them, and they were in an LLC, and neither of them had an operating document. And the girlfriend filed the annual report and removed her ex-boyfriend, the other business owner, from the records with the state. So making it look like she was the only owner. Well, we had to dispute that transaction. And because they didn't have an internal operating agreement, in this case, the operating agreement for an LLC, we had to actually find tax returns, checks from years ago, emails, and create this whole situation to prove that the ex-boyfriend was actually an owner in the business and was improperly removed from it. And I promise you, if you just take the time to create the internal operating agreement or internal operating document at the beginning of your business, or if you're already in business, sitting down with your partners and drafting one now, it can save a lot of headache and pain and potential litigation in the future. Now that we've talked about how wonderful limited liability protection is, let's turn to how you can possibly lose that limited liability protection, because we've talked in detail that businesses have a separate and very distinct identity from its owners or related entities. However, just going to sunbiz.org and filing your articles and paying the fee is not going to be enough to avoid having that personal liability, where rather than just coming after your business, creditors and litigants can come after you individually. You do have to actually walk and talk like a business entity separate from your individual self. So this concept of breaking that personal or limited liability protection that LLCs and corporations offered is called piercing the corporate veil. And that refers to a situation where courts put aside that limited liability that you thought you had and hold a corporation's shareholders or directors or an LLC's managing members personally liable for the company's actions or debts. And veil piercing is most common to, I'm assuming, everyone that's tuning in today in small businesses. So let's take a look at ways that the veil is commonly pierced so you can avoid piercing the corporate veil in the future. The first is to avoid fraud, wrongdoing, or injustice. That seems really obvious, But I'm going to present an example, which is the most typical example of how courts pierce the corporate veil. The example is that a claimant is seeking to pierce the corporate veil, meaning hold you personally liable. They don't just want the assets in your business, they want your personal assets. They want to be able to attach to those and collect from them. So a claimant is seeking to pierce the veil because of the wrongdoing of the company and its owners. Creditor of ABC Corporation receives a final judgment for money damages. Say someone slipped and fell on your premises, or you sold a product that hurt somebody. They sue you, and now you've lost. So that creditor of your company, hypothetically ABC Corp, that creditor has a final judgment, and that final judgment says they're entitled to money damages. ABC Corp cannot pay the judgment so that it shuts down. If ABC transfers all of its assets to, say, XYZ Corp, and XYZ Corp is operated substantially by similar business owners with the same assets and same employees, this could be construed as fraud or wrongdoing. So in this example, it's likely that ABC Corporation engaged in wrongful, potentially fraudulent actions by shutting down its business, essentially moving all of its assets over to a business that pretty much was very similar and the same. Even though this is kind of legal on the surface, once you look at the reasoning for transferring those assets, the whole reason the assets were transferred were to avoid having to pay the creditor in the first place. And that is how it creates a fraud. And that is when a court will look at that situation and say, wait a minute, this was wrongdoing, and we are now going to hold you personally liable, meaning we're going to let this creditor come after your personal assets, not just your businesses. The takeaway here is to take an outsider's perspective on transactions and business decisions. If you are the creditor in this situation, does this situation seem right or fair that a judge said that they were entitled to collect money from the company, but you moved the assets, closed down the company, and moved it to pretty much the same company? Again, this is the most common example. And there are certainly ways that you may go about moving assets and protecting yourselves in case you're being sued, but it's absolutely vital to talk to an attorney about that before you do it, so that you don't have that action treated as some kind of fraud, wrongdoing, or injustice that would cause you to have that personal liability and piercing of the corporate veil. Another common example common way to pierce the corporate veil is to keep your company separate from other entities as well as yourself. This, I think, is actually the most common in small businesses. It's a failure to maintain the separate identities of your company and your other companies, if you have more than one, or your company and yourself individually. So if you have other companies, and maybe like a parent subsidiary kind of situation, and the officers really need to ensure that the business is kept separate. So that means that they have separate bank accounts, separate contracts, and that's really, really important, because as I said, when you have an LLC or corporation, you're taking your individual self and separating it from your business. Well, if you have your business and another business that's a parent or a subsidiary, that also needs to create that separate legal identity. That's really the point here. We're showing that they're actual separate identities that courts, there shouldn't be any confusion or overlapping. That means everything that business A does should be, with its own bank accounts and its own written agreements, and those be different from your parent or subsidiary corporations or other businesses that you have, keeping things clean. But in addition to failing to maintain separate identities with companies, also people regularly do that between its owners and shareholders. And so this looks like an owner creates a corporation or LLC and continues to operate out of individual checking accounts, or fails to recognize corporate formalities. So again, that would be keeping good records of your business and major decisions, keeping records of who's voting on what dates you met, just any major decisions. Record keeping is really, really important. Showing that you have written separate agreements for each of your businesses, or anything you can do to keep with those corporate formalities is going to be really important. That's the first thing a small business doesn't do, because especially if it's a small business, 2 to 4 people, because they think, well, why do I have to keep up with all those formalities? It's just me and my spouse. Well, because not keeping up with those corporate formalities may allow for piercing the corporate veil. And use that company's, the most common failure is to use your company's assets as if they were your own. That means you're regularly going to McDonald's or getting lunch on your company card, or you're paying for a personal bill with your business's bills without making that tie to your business. And again, that's something you'll want to work with your tax professional on, to make sure that what you're claiming as a business expense is truly a business expense, because there are so many ways that you can claim a business expense that might be a little bit more of a personal expense that will raise tons of red flags for IRS that will eventually lead to a very expensive and lengthy audit. So in my opinion, your lawyer, your accountant, and your insurance agent are really the 3 pillars to your business that you want to keep checking in with. You're doing the right thing. So officers and owners of the business can ensure distinctness in the company and the owners by avoiding commingling funds. So you want to have separate bank accounts. Don't be commingling and mixing up the funds from your business and your personal. And that is the biggest way to fight piercing the corporate veil, by keeping things separate and keeping good records. Another way to pierce the corporate veil is to failing to adequately capitalize the company. Business owners are not necessarily punished by courts for not making enough money, or for not running a business, or for running a business haphazardly. Maybe you miss a few corporate formalities here, you didn't document a couple of decisions and meetings. It's a pattern of those things, or it's a really big issue that you missed. But a couple ones here and there likely won't add up to piercing the corporate veil. However, determining the capital necessary to cover reasonably anticipated liabilities, so reasonably anticipated costs and liabilities, where you may be sued, where clients may need to come to your business, and you need to have a certain amount of funds. And that's going to depend given on the nature and magnitude of the business. So it's very business specific, so if you're a taxi driver, you're what's considered adequately capitalized in your company is going to be very different than someone who is a baker. And someone who is a baker's adequately capitalized in the company, very, very different from any of you that may be in the construction field. So we want to make sure that our businesses are adequately capitalized, but again, it's very fact specific on the kind of business that you're in. And the normal operating costs of the business must be accomplished at the outset. So courts have held that a later infusion of capital into your business was not enough. So you want to start, when you have your business plan and you're figuring out what kind of money and capital that your business needs to start, you want to get that right the first time, because again, there's been a slew of cases that have said putting money into the business later did not make up for not having it in the first place. Courts will also look to the assets of the company to determine if the company's level of assets available to creditors is fair. So we're just making sure that a common situation that may come up in your business that may create a creditor or litigant, that there's enough in the business to pay them. You don't want to just start your business with $0 when, a creditor can come after you, and a court will say, hey, you started this business with nothing in your bank account, and you have a kind of business that should have been better capitalized. So again, I'm sorry if this is confusing, because it is very specific per each business and industry. But when you're developing your business plan and you're working with your advisors at SCORE or the Urban League or Goodwill, they can help you determine what this adequate capitalization is. And finally, there is no clear standard for assuring that the new corporation or LLC is adequately capitalized. And to reinforce, a well-prepared business plan with both projections for income and expenses is a really good start. So sit down with those free resources, come up with what the projections for income and expenses are, and you'll have a much better idea of how to adequately capitalize your company to avoid piercing the corporate veil. Also, failing to follow corporate formalities. We kind of touched on this in all of them. A corporation or LLC should undertake necessary formalities. These are more formalities than a partnership or sole proprietorship is going to have. And in order to get that limited liability protection, we need to actually keep up with those corporate formalities. So that means updating your bylaws or operating agreement, those internal operating documents, maintaining stock for corporations or membership ledgers for LLCs, who's actually an owner, who's paid what into the business, what they've received back from the business, holding initial and annual meetings of directors and managers and officers. So actually get all of the business owners on the same page ever so often. And of course, maintaining status with the state of Florida by filing an annual report. So each May, all businesses in Florida that are LLCs or corporations are asked to submit an annual report and pay a fee about, I think it's about $65. And that's pretty much the state just looking for information to update, make sure the owners are still current and up to date, make sure that the address is still current and up to date, the emails on file, because the state may send correspondence to those addresses and emails and business owners, and they need to make sure they have that updated information. The business activities should be documented and records should be adequately kept and stored, and the parties with whom the business is conducted, that should all be maintained in your corporate records. Sometimes a bit old school, but it's called a corporate book. You can actually purchase a physical corporate book if you don't like having your records online, like in a Google Drive or Dropbox. If you want to actually physically own and hold a corporate book where you put all of your major decisions, your internal operating agreements, your big contracts you enter into, I like to think of a corporate book as like a storybook for your business. You open up the first page and you should see the date you incorporated, your articles of incorporation, then your internal operating agreement, your bylaws or operating agreement, flip the page, who are the owners, what dates have they been the owners, how long, what's their percentage, what's their capital contributions, what are they owed from the business, who's managing the business, who's merely an investor in the business, what are the major agreements and contracts that the business has entered into, such as commercial leases, vendor agreements, client template agreements. So if you ever want to sell the business or you want to get money from a funder or you want to get grant money, you can show them this corporate book hypothetically, and it tells the story of your business and it shows that you have been keeping good corporate records. So again, this really happens, a failure to keep these corporate records happens most commonly in family-owned businesses because naturally they're going to be less meticulous maintaining those corporate records, but that lack of formality does leave room to pierce the corporate veil. And we had already talked about filing an annual report. I just want to emphasize, once you've incorporated your business, this annual report is due every year in May. This year it was actually extended due to the pandemic, but other than that, it's been due May 1st every year, and it's updating your records. It keeps you in active status with the Florida Department of State, so it keeps that liability protection. It's really important not to miss it because of that active protection, but in addition, there is a $400 non-negotiable late fee, and so you don't want to have to deal with paying that or having to incorporate a whole new business, because $400 is a lot of money, and there is no calling the state and saying, oh, I got into a car accident that day, or my kid was sick and I had to get them from school. There is no negotiation. They will charge a $400 fee. So it's really important you get that annual report filed on time every year. And to emphasize, I am not a tax expert or consultant, so I'm going to be talking very briefly and basically about taxation. And legal entities have a choice about what tax entity they want to identify as. In other words, how your entity is taxed may be different from your entity's legal structure. So the different types of tax entity examples are C corporations, which is generally better for larger corporations, S corporations, generally best for smaller corporations, and sole proprietorships. So for example, both an LLC and a corporation can choose to be taxed as an S Corp, even though, they're different legal entities. And I usually like LLCs because LLCs have more options when it comes to choosing a tax identity than corporations do. And both legal and tax entities offer certain benefits, but it really is best that you consult with a CPA or tax attorney that understands the ins and outs of your businesses so they can help guide you to whichever structure is best, LLC or corporation, and how that corporate structure should be taxed. For a single member LLC, so just one person owning the business of your limited liability company, my most common entity is a single member LLC for my clients. And generally, tax professionals say it's best taxed as a sole proprietorship. So you can have that limited liability, but not have the headache and actually file your taxes as a sole proprietor. So it's really essential that you work with a tax professional, or if you're not able to afford one, reaching out to SCORE, Goodwill, or the Urban League in Broward County, the other two in Collier County, and seeing what they can do to help get you some tax guidance for your new business. We already touched on DBAs, or fictitious names. So those renew every 5 years, or if the change in the business ownership occurs, you need to file a cancellation and re-register within 30 years. So not just for sole proprietorships that we previously talked about DBAs for, but if you're an LLC and your LLC is ABC LLC, but you want to call yourself Judy's Bakery, that is not, you need to actually register that fictitious name. This also helps protect your limited liability because you're connecting that fictitious name or DBA to your actual limited liability company. And when you make that connection, you protect your liability. But to make that connection, you have to register both with the state so that when consumers look you up in public record, they see Jane's Cakes, or whatever example I made, Jane's Cakes is actually the doing business as name or fictitious name of ABC LLC. And that is a $50 filing fee. So to briefly review, because I want to be sure to leave a few minutes for questions, how to start a small business if you're someone new to it. You're going to need to file your articles on sunbiz.org. You're going to need to create your internal operating document, your bylaws or your operating agreement, depending on if a corporation or LLC. Of course, first you should work with SCORE Naples, Southwest Florida Goodwill Micro Enterprise Program, or Urban League of Broward County. Also, the Florida Women's Business Center in Broward County is a great resource. First, we want to do the business plan. But if I'm able to represent you or you work with legal counsel, then the next steps once you have that business plan are to file the articles, create the internal operating agreement. Next, as you're running your business and starting your business, remembering to maintain those corporate records. So a copy of those articles, a copy of those bylaws or operating agreement, putting it into a corporate book, whether it's physical or it's a drive you keep on your computer. And also including other big decisions, changes of ownerships, changes of percentage in ownerships, documenting what people put into the business, financials, putting your financials in this corporate book, and other measures. So we're keeping up with the business in order to avoid piercing the corporate veil and losing that limited liability protection. And then remembering to file the annual report that's going to be due each May. And finally, making sure you have the right agreements in place. So 6 days from today, it will be Tuesday, November 10th at noon, right back here on the Zoom link. And you'll see on all of our legal aid of Collier County's social media pages, we'll post more information as well as a specific link to watch a webinar where we'll talk about written agreements that commonly face small businesses. So that's a really great addition into today's topics to kind of finish out that what we're calling a small business legal boot camp. So making sure your business has all the right agreements in place. And I want to leave the remainder of time for any questions or clarifications I can provide. I want to mention one more time that if you are interested in our free legal services for small businesses or nonprofits, you can email Sherry Despointes. Her email is on the screen as well as her phone number. She's our paralegal and intake specialist, and she can answer any questions you have about our eligibility guidelines. And if you qualify for our services, walk you through the intake process so that you can be set up with an attorney. And then I'm going to backtrack this to the first slide so that you can have my email if you're interested about any of the free resources I've talked about in Broward and Collier County, or if you're looking for free resources outside of those counties. For example, if you're cleaning up your financial records right now, SBA Partners will actually provide free resources to help you clean up your financial records so you're in the best place to qualify for the SBA disaster loan, for example, or Collier Cares funding or grants in your county. So if there's any resources that we can provide you other than those mentioned today, please feel free to email Sherry or I, and I will leave the remainder of time for questions if there are any. Thank you.